Hi everyone and welcome back. In this video, I will focus on some general information in regards to the criminal process. So on my previous video, I mentioned about the first appearance and the initial disclosure. One thing that you have to understand that the initial disclosure is not the only disclosure or evidence that the Crown must provide. The Crown has an obligation to provide everything, and this is an ongoing obligation. So you might have 2, 3, 4, 5, 6 appearances where the Crown is constantly providing disclosure, and it is also upon us as defense counsels to ask for or to request disclosure if we think that we have not received all of the disclosure that there is to the case. Another important thing are the Crown pretrials. So the Crown pretrial is not only one Crown pretrial, but there can be a couple. So what a Crown pretrial usually entails is a conversation between your defense counsel and the Crown assigned to the matter. This can happen in person, over the phone, or through email. So depending on what charges you have, sometimes we also have to provide proof to the Crown. For example, in a domestic situation, if you have completed therapy, or you are in therapy, or you've completed an anger management course or anger in relationships, then we have to provide completion certificates to the Crown. So essentially, it's very good to have a lot of conversations with the Crown because it means that we're coming to a resolution to try and avoid going to trial if not necessary. Now, there are matters where defense counsel and the Crown do not see eye to eye, and the Crown feels that this matter should go to trial. So the next step would be a judicial pretrial, and a judicial pretrial is a meeting between the Crown, defense counsel, and the judge. And usually this is where we want a judge's opinion. Again, usually there's one JPT, but we can have more than one judicial pretrial if there is a potential for a resolution in the case. So as you can see, there are some steps prior that can be taken to see if the case can be resolved prior to going to trial, just so that we avoid that delay and we try to come up to a favorable resolution for our client. It's always important to understand that each case is different because it depends on the facts of the case. So some cases will resolve quicker than others, and the other cases perhaps will end up going to trial. But like I mentioned before, it's quite important to be patient and to always be in touch with your defense counsel in case you have any questions or concerns. For more information, please head on to our website www.bracelaw.ca, and if you or anybody that you know is in trouble, please contact us right away. Stay safe, and I'll see you next time. Bye.